Okay, everybody. Well, welcome. I see everybody's anticipatory looks. I appreciate you coming in and being a part of this conference. I haven't met Jennifer in person, and it's a blessing to be able to meet, virtually. We've spoken on the phone a couple of times, and our church members know I've been talking for some time about the need to have pre-planning, wisdom, and, estate planning, things that as a pastor, I encounter a lot, not just only in death, but in people who are struggling to help somebody who has passed. And so it's in my heart to have Jennifer come. I met her virtually. In fact, Ophelia Wellington and Wayne recommended Jennifer. In fact, a couple of pastors I asked it, talk to Jennifer Norton. So I'm so happy we had this chance to schedule. And we try to do this face-to-face. Of course, nobody can meet face-to-face now, right? So we're just happy to have you. I'm going to admit some other people here. Yeah, Zoom has changed their security. Now you have to admit people manually. That's the change they made. And my first Zoom session, I didn't know that and left everybody out in the waiting room. So I'm watching now to make sure I don't miss anybody. Okay. All right, let me share this. First of all, this is a brief bio that Jennifer has on her website and sent me by email. And you can take a look at that if you can read it. But I love this, her approach, her passion that she's taking toward estate planning and focusing on the elderly as well. I see that she's an Indiana native, went to IU Law School. I see that. And she has credentials and memberships and much experience. So I really appreciate that we have her in this session on tonight. Really appreciate this. Okay, so there's her information. Of course, I encourage you to contact her as I plan to do. There's a lot to consider. All righty. Okay, well, that said, again, if you cannot hear me, please send me a chat message. Let me know. Raise your hand and let me know you cannot hear me. I want to make sure that everybody is on board and ready to go. All right, I guess we're all good. Let's have a word of prayer. Father, thank you for this session of wisdom and insight. Lord, practical wisdom. Lord, information that we need in this season of our lives together. Thank you, Father God, for just opening our hearts to receive this insight. Thank you for Attorney Norton, that you've given her grace for this season. And Lord, thank you that we would be able to get our questions answered and gain understanding and learn from her presentation. And we thank you for this time together in Jesus' name. Amen. All right, so our plan is we're going to have Ms. Norton to give a presentation. We're not going to have interaction until the end. She has received your questions, the questions you submitted when you signed up. I sent those to her, and she said she can answer all those questions. So we'll give her ample time to do that. So that's about it. So again, thank you for being on with us today. Thank you, Ms. Norton, for being on. And I'm going to pin your video and put you on the front right now. So welcome, Ms. Norton.
Okay, perfect. Thank you. Okay, here we go. Well, thank you again, Pastor Hudson, for having me. I thank the Wellingtons for thinking of me and all the other pastors that I've serviced. Thank you for, letting me spread my love of estate planning and my passion for this topic. So tonight, what we're going to do is we're going to just talk about the basics, things that you always wanted to know, but didn't necessarily know what to ask, how to ask it, or even know that it was an issue. And so I'm going to try and start out with just the foundation so everyone has the same footing and same basic knowledge about how estate planning is. And then we can get to some of these questions that are kind of more nuanced. And like Pastor said, feel free to throw it in the chat, write it down. I'm happy to stay on as long as you want to get the answers that you need. And if I need to come back or you need to speak to me later, I'm more than happy to assist. And so I'll start the program and to just say welcome. Like I said, thank you for taking time out of your day You could have been doing a lot of other things. Well, not necessarily in this quarantine, but there are other things at home you could have been doing. But I appreciate you guys sticking around with me. And like he said in my bio, what you'll see here is just me. I'm from Indianapolis, born and raised, graduated from Cathedral High School, went to IU in Bloomington. I actually have a degree in finance from their business school. And then I went to their law school. When I graduated, I realized two things. I don't like going to court and I don't like arguing. So I was kind of in a conundrum there because in undergrad, I realized I didn't like finance and I felt like, oh my God, I don't know what I'm going to do now. The great thing is I ended up working for the National Network of Estate Planning Attorneys. I worked for the CEO for about 4.5 years, and we trained attorneys across the country on how to practice in this area called estate planning, preparing plans, being flat fee, getting the education out there first so people could understand what their options are before they have to settle on a specific type of plan. And of course, the reason for my planning, the beat in my heart is my son. There's Ty. That is when he was 3. He's 7 now, but that's my favorite picture of him. I think it was like his first real school picture. And so he's my why and why, I choose to, dive deep into this practice and then commit myself fully to the families that we service. So the first question most people ask me is, what is an estate? I don't have an estate. Actually, everybody has an estate. An estate is everything that you own. It's your bank accounts. It's your house. It's your car. It's the stuff in your house. It's cookbooks. It's family albums. It's everything is embodied in your estate. So when people say, I don't have an estate plan, that is incorrect. Everybody has an estate. In fact, the main thing that you want to think about sometimes why people consider themselves as not having an estate is they haven't figured out, why am I doing this? Why in the world are you here, right? Why should I be doing an estate plan? Who does it fit? What is the profile of an estate planning client? Well, I always tell people people always assume it's people with children, right? Especially blended families, because you have money that can move different kinds of ways in the bloodline. You could unintentionally disinherit bloodlines if the money moves the wrong way. People think when people have minor children, of course, they need to be protected. But again, the other typical profiles, people think that people who do estate planning have to have assets, whether it's a lot or a little, regardless, whatever you leave to someone else, it's more than they had. And so that is a lot. So whether you compare yourself to these, someone else, or, that you think has more money than you, believe me, your beneficiaries believe you're all wealthy. Okay. The third profile of people that think are typical of a person that needs estate planning are people with protection. So people think people that have disabilities, people that are special needs. Of course, the minors comes in. The older we are, we think that we can be taken advantage of. So of course, these are the people that need some type of protection and estate planning. Of course, people who value privacy. So that if you're one of those individuals, it's like, I don't want the world to be able to see my plan. Well, whether you do a will or trust will affect that result. And so people think if I do an estate plan, I can gain that privacy, which is true, but you have to do a specific type of planning. And we'll talk about it. The other profile is people that desire tranquility. Everybody wants organization. They want it to make it easier for their beneficiaries at their desk. They don't want to be a burden to people. And so in order to do that, those type of people with that characteristic think estate planning will give them and my family that peace of mind. The last profile is people who desire to leave a legacy, right? So people always think, especially my single clients with no children, well, what's the point, of doing estate planning? Well, I'm always going to challenge everyone, whether you're single, married with children or not. How do you want to be remembered? How do you leave this earth better than the way that you found it? What will be your impact and the legacy that people will always turn to or fall to when they think of your name when you're gone? And so normally what happens is people fall in any of those, multiple of those categories. And essentially estate planning is for everybody. And so what you have to figure out is, okay, now what? What type of planning? And only you know that. So the question is, should I be doing a will-based plan or should I be doing a trust-based plan? Now, the goal is you have to beat the clock, right? And we know not the time nor the hour of when our death will occur. And so the clock, even though it's always running, you don't know when you're out of time. And so really the time is now. And so as Pastor was saying, everyone always thinks of estate planning as the death portion. After, I want to leave instructions for my final inheritance, my final distribution. But as he said, what happens if you're alive and not so well? What if you become disabled? What's the plan then? And so where we start out, and I find that most people fall into this category of not having a will, right? So if you don't have any type of documentation, what you have is a probate. A probate is a morbid scavenger hunt, where people are trying to figure out what you have, where is it, where do you bank? And there's no real registry where we can dial up, look on the computer, make some phone calls to figure out where everything is. Now, we may stumble across a statement or some type of bank account or some type of old checkbook. And this gives us a roadmap or some indication that you might have housed assets there, or you might have something that needs to be claimed from that institution. But there really is no registry. And so because of that, the court says, since you don't know where everything is, the probate court's primary concern is we want to make sure a person's final debts, taxes, and expenses, that's funeral expenses, your CPA expenses, your school debt, these things need to all be resolved prior to your beneficiaries inheriting, because they are well aware that once you give the beneficiary a check, the odds of us receiving it back in order to catch or reimburse or pay a claim that we had overlooked or missed are very slim. So, once they get the money, it's typically gone pretty quickly. And so this leaves the court also concerned with creditors, right? So when a death occurs, the court says, if you don't have a plan, we need someone to be the executor of the estate. And as long as they're over the age of 18, they've not committed certain types of felonies like financial crimes, abuse of elders, then they can be the executor of the estate. As you can see, we like it to be adults, even though maturity is sometimes questionable when it comes to who gets appointed. And so as estate planning attorneys, our challenge is not only moving the finances, but managing personalities and interfamily relationships. Because all are welcome. The court doesn't really care who gets appointed. Now, you think it should be next of kin, but it doesn't have to be. It's the first person to the courthouse. And so what we're looking for is them not falling into one of those categories of, certain felonies and being minors. But as long as they're competent, the court will appoint them. And once they've appointed someone, if someone objects, they have to prove that the person that the court has blessed is somehow inefficient. They've missed something. Because other than that, the court thinks they've got it right the first time, essentially. And so because a person doesn't know what you own or where it is, the court says, let's publish notice of your death in the paper, because you don't also know who they owe either. So we run notice of your death, and it runs for 90 days in your local county paper. It runs 1 week, and then the following week has to be consecutive. And those creditors have 90 days to file into the estate and say, hey, he or she owed me a debt. Now, they have to show evidence of the debt, swear under penalties of perjury that the debt still exists, and pay a filing fee to the court. If they fail to pay the filing fee, the court will disallow the claim. They'll say, we're not going to let it go forward. But if they've done everything, at the end of the 90 days, the court will say, hey, you parties, you can work it out amongst yourselves. Or if you want, I can have a hearing, and I'll tell you whether I will disallow the claim or allow it. And usually at that point, we tell the judge, hey, we'll figure it out amongst ourselves. And our goal is to pay pennies on the dollar. So we treat them just like a creditor, and we'll try to pay 40 cents, 30 cents, 50 cents on the dollar so that we can keep as much of the inheritance for the beneficiaries as possible. Because what happens is most people don't like probate because they say it takes too long and it costs too much. And so where you look at the probate process is the filing fee is only about $180. To file in the recorder, it's about $90. And so the overall cost of probate is like $300 or less. So what's expensive about probate, it's not the process itself, it's the attorneys. And so our solution, our recommendation is you need to get yourself organized today. And what that will do is it will save your family's heartache. And so what we do in our practice, you're welcome to email me, and I can get this to Pastor Hudson, is we like to give our clients this personal information form. What it lets you do, it's about a 22-page document. It allows you to lay out where you bank, where your investments, do you have health insurance, long-term care insurance, disability insurance, do you have timeshares, lots, safe deposit box, bonds, stocks, All those different types of assets are important, because how do we know if you're getting a pension? What if you live in one state, your beneficiary lives in another state, and that bank's not there? So they try to move your banks, but forget to grab your pension. And so sometimes people have multiple pensions. Some are really big and some are small. And so this personal information form just helps us. Who's your primary care physician? Who is your property and casualty insurance agent? Remember, that's a prorated check. So if you die in the middle of the month, we got 15 days worth of that bill that should be refunded to us. But if people don't know who insures your cars and your houses, we can't get that check. You'll have to wait about 7 years or whenever it falls to Indiana unclaimed. And then we got to go through this process a little bit all over again in order to claim that asset. So you're welcome to email me. I will get the form to Pastor Hudson so that way he can get it to you. But what you want to do, you don't necessarily need my form, though it is very helpful because it accounts for assets that you probably aren't even thinking about. But what you want to do, even if you get a binder and just start one sheet of every statement that you own, or where you have access to things that people wouldn't naturally find without, you leaving some type of instructions, that would be, it would be so helpful. Your beneficiaries will have to thank you when they're in heaven because you're not here. But essentially, let's talk about the next type of document that's out there. It's a will, right? So everyone knows, sometimes people confuse. I was just arguing with somebody on Facebook today. I hate social media sometimes, but it really burns me up when misinformation gets out there and my people are just being led astray. And so there is a difference between a last will and a living will. A living will is you are alive, but not so well. So would you want to be prolonged with artificial nutrition and hydration? A last will, and people shorten it, it's called a last will and testament because it's testamentary, which we all know from the Bible, after death. And so these are your instructions for after a death occurs. Well, what the instructions do in a will is it allows you to also pick your personal representative, the person that you want to run the money, run the administering of your estate, telling people what they need to do, how they need to do it with the guidance of the attorney. That's why they're called your personal representative. You personally selected them, and usually you'll have a backup listed as well. Because our goal is we want to hit the target. And so a will allow you, I know what I forgot. A will allow you to make sure that the beneficiaries that you want to inherit will inherit. Because when you have no will, if you have not left any indication of who the beneficiaries are, then there is a statute that will determine who will inherit. And the statute typically in Indiana, people think it's all to the spouse. That is incorrect. In Indiana, if you die without a will, it's half to the spouse, half to the children. And if you're in a blended family, there's a different split. It's like a half, you get half of the personal property, or a quarter, 25% of the property, and a third of the personal property, which is like the stuff in the bank accounts. But the real estate, you only get 25% of. So the split is not what you think it is. The only reason things go all to the spouse is if your name was jointly owned things, right? But if you leave things without joint ownership, when you have no plan, we're going to look to the statute to see who should inherit. And so in my stories, the husbands always die first. Fellas, do what you want, but you're going to die first in these stories, okay? So when you die, everything will go to your spouse if you're married. If you're not married, but you have children, it will go down the bloodline. Same thing, when the wife dies, it will go down the bloodline if you have children. If you have no children, it comes up, and we look across if you think of a tree, we're looking on the row of siblings. And if siblings are there, they will inherit equally with a parent if a parent is alive, because we don't disinherit parents. If a parent is not there, then the siblings will inherit equally. And if a sibling has died, their children will inherit their share. So we're looking for a row to hit where someone is alive, and then we pay out on that row. If you do a will, you can bypass all of that, because in your will, you're going to say the instructions. You may say all to my spouse, or all to my children, or I want to split between my nieces and nephews and my children, or my godchildren, or I want to give philanthropy. I have some philanthropic goals. I want to give to my church. I want to give to charities, causes like Alzheimer's and dementia and things of that nature. Well, you need a will or a set of instructions to do that. And so the will helps us to hit the target just a little bit there. You see where it's slightly missing the mark. Because what people don't know are two things about wills. And the first is wills only control things in your individual name. So if you own things jointly, with the spouse, with children, with your best friend or your niece or nephew, if their names are jointly on accounts, when a death occurs, by law, that ownership will transfer to that joint owner. If you can't strip someone of their ownership just because you died. So in comes your beneficiary or your surviving spouse, if you're married, with a death certificate. Your name will fall off, their name will remain on that account. It's the same with life insurance. Wills do not control life insurance. Those have beneficiaries on them. They're contracts, just like retirement plans and annuities. And so when things are jointly owned by law, it's going to go to that joint owner. If you want your will to control anything, you have to leave it, break the joint ownership and leave it in your individual name. Because now institutions want to know, well, who should get the money? Well, we need to go look to the will to see who and how it should be distributed. The second thing that most people don't know about wills is all wills go through probate. So you think that by getting a will, I can avoid that court process that I just talked about. But actually, you walk right into it. One, because the institution is very concerned about who they give the money to, right? They don't know. Say you have a will. I'm your executor. If I come into your bank account and say, hey, banker, turn over the account. Here's the will. I'm the personal representative. And I'll take it from here. They're going to say, Jennifer, we don't know you. Your name's not on this account. Your name's not on the check. We don't know you. And I can say, well, here's my ID, match it up. But we all know, we are wiser now, but we all know people who have had fake IDs, at times before. And there are still people that make fake IDs. And so banks aren't trying to rely on their own sophistication when it comes to analyzing a driver's license or an identification. And so they say, go to court, let the judge sign off on that you're a good person and that you are who you say you are. The second reason why is how does the institution know that I didn't drug my loved one? How do they know I didn't forge their signature? There are many of my friends in school knew how to forge their parents' name. I have awful cursive. But if they had the ability to mimic someone's signature, they don't know the difference. It's not like they're bringing in handwriting experts. And so the institution says, go to court. Let the judge say, this is a good will. You followed the formalities. You weren't coerced. You were over the age of 18. You signed in the presence of each other. All the formalities of a will, they want to make sure they've all been met. And then the institution will take their instructions. The last reason why I believe that wills go through probate is because most attorneys will sell you a form, right? So you see the guy over there, what's your name? Are you married with children? How do you want the money divided? Great, who should be the representative? Those are the basic questions they ask you. But if you remember what we just talked about, probate is about the money. Where is the money? Because the beneficiaries only have two questions and two questions only. Where's the money? When do we get it? And if an attorney has only drafted you a form that says all bank accounts to my two children, well, the children come in and say, well, great, Jennifer, where are all the bank accounts? And I'm supposed to say, well, I thought you talked to them about it. Half the time, most of our families don't even know we did estate planning. And so there is a big disconnect between what the document says and where the assets are and who knows about it. And if you're single, you've already died. So you can't come back and you can if you believe in being able to rain down and give instructions. Sometimes it happens. I don't know, divine, you might have some divine transmission. But from what I know, most of the time that doesn't work. And so what you want to do is get yourself organized today, because most people say there are two evils of probate. Takes too long and costs too much. Takes too long, of course, because we got to wait that 90 days. Costs too much again, because attorneys are billable hour. And when people are grieving and they don't know what to do, what happens is they turn all of this over to the attorneys. And this is where it begins to cost too much. And so essentially, whether you do a will or don't do a will, you now know they all go through this probate process. So now, are you still lost and confused? Like, what the heck, Jennifer? How do I solve this kind of conundrum, this cycle that is presenting itself? Because I don't want you to chase your tail. And so what you can do is, my recommendation, in the state of Indiana, you can put beneficiaries on everything that you own in this city. So if you decide that you want to do a will-based plan, but you want to avoid probates, you can put beneficiaries. It's called a transfer on death beneficiary. You can put that on your bank accounts. So then the minute a death occurs, by law, that ownership has transferred to whoever you've listed as the beneficiary. They just don't know that you died. So they have to come in with a death certificate, and then they'll turn over the accounts. And they only talk to the people that are beneficiaries. I don't know if any of you have tried ever calling in and you're not a beneficiary listed, you get snuffed real quick. They do not let any information out to anyone that's not listed as a beneficiary. In Indiana, you can go to the BMV and you can put a beneficiary on your car. And that way you can avoid a probate there. And in Indiana, you can do a beneficiary deed. It's called a transfer on death deed. Again, the minute a death occurs, by law, ownership has transferred. The recorder's office just doesn't know you died. So what you have to do is file what's called an heirship affidavit. Swear on an affidavit, I am the heir, I am the survivor. If you're married, to get it out of your husband's name, you find what's called a survivorship affidavit. You're swearing on an affidavit, I'm the sole survivor, put the property into my name. So in Indiana, like I said, you can avoid probate by putting beneficiaries on everything that you own. And like I said, I don't like going to probate, and I don't like going to court if I don't have to. So we have about 350 client families in our practice. And so about a third of them have will-based plans. But how we keep them out of court is we put beneficiaries on everything that they own. And then we follow up and get documentation from that institution that they have it on file. I just got a call the other day where some institution, I think it was Chase most likely, no, it might have been PNC or something, said that the account holder sent in change of beneficiary form, but he signed in two places. And one of the places he signed on the wrong line. He did that in 2015. Do you think the bank called to tell him he signed on the wrong line? Of course not. So now when the beneficiaries are calling to get the money, they're going to say, unfortunately, we can't honor this designation because he signed on the wrong line. Well, why didn't you call and tell him, that you received the paperwork? And so there's this disconnect where you got to always trust your own eyes. Do not trust that you sent something in and that was done correctly. You want to get confirmation. You want to get something on paper that shows that your beneficiaries have been updated if you decide that you want to do a will-based plan. And essentially what happens in my practice is we'll never use the wills of my clients. The wills are just a backup. What if their long lost relative dies and leaves them an inheritance that they can decide where it goes? Well, because we didn't know we were going to be the recipient of it, the will now will direct it, because what if they chose to treat their children 60-40? So if they had no will, it would have defaulted 50-50, but because they had a will, now we know to follow the same pattern of 60-40. Next, so that wraps up wills, okay? So wills, so probate, we know we got to go through court, publish notice in the paper. The window of 90 days is there for the creditors to file in. And then at the end of the 90 days, we make a decision on how we want to settle it up, if it's a valid claim, or else the judge will kick it if it's not valid. With a will, all wills go through probate, what we just talked about, but they only control things in our individual name. So if we want our will to control those assets, then we need to take them out of joint name, because even though we're married, we may not have the same wishes in our plans, right? We have different alma maters. We want to leave different amounts. And the other thing we want to do is we now know that we can avoid probate, even though we have a will, but we just have to put beneficiaries on everything that we own. Now let's talk about the other document that's out there in the world, a revocable living trust. It's revocable because we can change it as long as we're alive. It becomes irrevocable at our death, meaning we've locked in our words, though our words could be flexible, okay? So don't get twisted. Just because it's irrevocable doesn't mean it can't be changed. It can if you've locked in flexible words. A revocable trust is just like a will. It's a set of instructions that tells your property where to go. Everything still stays under your name, under your social security number, except now things get retitled into the name of the trust. Now, I said I'm an attorney. Trust can avoid probate, does not mean it will. For a trust to avoid probate, you have to retitle everything you own into the name of that trust today prior to your death. Okay, so remember I said can avoid probate. What you have to do is go to the bank. I have a trust. My bank account is in the name of the Jennifer Norton Living Trust dated June of 2013. My investments are in the name of my trust. The deed to my house, even though I have a mortgage, it's just a lien, but I still own my house. So my house is deeded in the name of my trust, still with the mortgage. My life insurance, the beneficiary is the trust. My retirement plans, the beneficiaries are coordinated with the trust. I own a business, so the ownerships in my businesses are coordinated with the trust, because I want everything to funnel into the trust. Think of like a box. Everything needs to flow through this box because that's where my instructions are. My instructions will only control the assets in which the name of my trust appears. If in Indiana, if I leave too much out, when you get a trust, you still get a will. It's called a pour over will. It says, if I forgot anything outside of that trust, go get it, but pour it over into my trust where all my instructions are. But remember, I said all wills go through probate. So if we have to use your pour over will, we have to go through probate to fill up the trust, right? So stay with me. Why go through probate if you can fill it up today and avoid it? So if you have trust, then what you want to do is you want to take the time now and retitle everything to make sure the instructions in your trust will control those assets. Because other than that, is a trust really a waste of money, right? Because we're going to go through probate anyways. And so I would venture to say it is not a waste of money, because what happens is when the death occurs, like I said, we still have to pay your final debts, taxes, and expenses all off the top. We have to pay those that we reasonably can find. So we're not going to go looking for them necessarily, but if they show up on your bank statement like you've been paying them off, then of course we got to pay them. But anything that we don't know of, we're not trying to actively go find. And of course, we have to pay your final debts, taxes, and expenses just like under a will. But again, when your death occurs, the trust now becomes irrevocable, which all that means is we've locked in those your words. Now, why would I want to do a trust? There are a number of reasons, right? A lot of people say to avoid taxes, but I believe my clients are more altruistic than just taxes. But you can protect your beneficiaries from their later creditors. So when you're alive, everything stays under your social security number when you do a trust. So if you have a lawsuit, a divorce, or some type of illness, your estate is liable to that creditor, debtor, or situation. Your estate is tied to your social security number. So when I do a trust, I can't put my house into the name of the trust and then say, creditor, I'm done paying you. No, they'll just step into my shoes and say, we need everything titled and under Jennifer's social security number to repay that debt. And remember, when I do a revocable trust, it's still under my social security number, so they can take all my assets to recoup their loss. But when your death occurs, this is where the magic happens. We can protect people from lawsuits, right? We can divorces, and people are living longer, but not necessarily better. So that money is about Medicaid, right? Avoiding the costs associated with Medicaid. And what happens when a death occurs is little trustlets are set up. One of my clients called them like little LLCs. They're little lock boxes. They get their own EINs. And so because of that, they're not the beneficiary's social security number. If you're married, your first beneficiary is going to be your spouse. So you only have one trustlet, sometimes called the family trust. When your surviving spouse dies, you have these little trustlets for your ultimate beneficiaries. These EINs are not your beneficiary social security numbers. They're numbers we went and acquired from the IRS, just like if we were setting up an LLC. So that way, if your beneficiary has a lawsuit and they lose, the creditor says, we need your assets, beneficiary. They say, I'd love to give it to you. Not really. But those aren't really my assets. I don't own them. Go look at that social security number. I only have the right to use these assets for the terms for which my loved one has set up. So if you decide to do trust-based planning, the key is to leave things in trust. What you'll find, a lot of practitioners will leave it in trust for the life of the surviving spouse, but then at a death, pass it outright to the kids, right? And then they take it, put it in their bank accounts, in their investment accounts, wherever, but all under their social security numbers, which means if they have lawsuits, a divorce is about splitting marital assets, not inherited assets. But when people are married and they're in love and they feel real good, they have joint bank accounts. So they take their inheritance, put it in that account. But then when you die, all the love is lost. Then they want to go get a divorce. They go to the judge, say, Judge, he needs to take his, I need to take mine. Judge says, great, I'm about to split 50-50. Your beneficiary says, hold up, Judge, but I received some inherited assets. I want that back. Judge says, okay, sure. Show me how much. Now the new outlaw speaks up. Hold on, Judge, before you sling that gavel. Wait 1 second there. When her mother and father died, They left those assets to us. They sure did. But guess what? We went on vacation, paid down debt, bought new cars. Oh, we spent all that money. What's left in that account, that's our money. Judges, they do not do forensic accounting. They're not trying to figure out what money came in first, what went out last. They don't do any of that. They tell your beneficiary, I would love to give it to you, Miss Norton, but if you would have just set it in a separate account, so I'd have been able to tell what was marital money and what was inherited, we wouldn't have this issue. It's called don't commingle, mix together the monies. But that's not great counseling advice to tell somebody when they receive inheritance and they're happily in love and married, right? Honey, go sit your money over there. I'm gonna sit mine over here just in case we get divorced. I want to keep my money. Doesn't work like that. And so what happens is if you leave assets in trust, they don't have a choice. It is set in a separate account. It is separate. It is identifiable. And you can even control the terms, like a contract. So my son, he and his father and I, we have set up trust for him. And while he's a minor right now, he can't own things in his own name. So even if I did a will, I'd still have to set up this trust for him. And so this trust will say, I can set the terms because I can say whatever I want in the trust. And what I would say is while he's under a certain age, I picked 22, he doesn't need to be worried about money. I'm going to pick who runs the money. So I put him, think of it like training wheels. You know, you don't just jump off onto the two-wheel bike and hit the ground running. You start off with your tricycle, right? And you might even start off with the little wheelbarrow, the little one that's real close to the ground. And so that's what you need to do with beneficiaries. In my experience is you have to train them up into this inheritance because most people blow through the money in the first 5 to 10 years. And so what we said is while he's under the age of 22, we picked who runs the money. At 22, he can come on like a co-pilot. And I need him to start learning about the finances because how well were we trained about finances, right? A lot of us had to learn ourselves. Well, if we know that didn't work very well, why do we keep passing on these generational curses to our children? We need to change the trajectory. And generational curse is a whole nother presentation that I got, but we need to do something different. And in order to do something different, it gets a little uncomfortable. We got to pay a little bit more to get a little bit more, but it's worth it. And so what we do is while he's age 22, he comes on. And I said he has to work with my financial advisor. He can't just go pick an advisor. He didn't even know what he was doing in the first place. Why would I let him pick one? Some clients, if you don't have a financial advisor, you can set up the type of advisor he should have. They need to be practicing X amount of years with X amount of designations. And then when is this training over? Well, I said 40, right? Even the world's wealthiest people said their children weren't ready to the age of 40. And so if they don't think their children are ready, why should I believe my son is any different? And I ain't wealthy. And so because of that, what I said is at 40, he can be his own trustee. Trustees run trusts, but I've confined him to interest only because remember, like I said, my son might be a patient man. He might be waiting to 40 to go blow it all gambling or something. And so what I did is I said, nope, interest only. And then and for him, it's no principal because right now I have a lot of insurance. And if I died young, money typically doubles every 9 years. And so by the time he's 40, that should be millions of dollars if I died within the next 2 years. And that's how you need to be thinking when you do your planning. If I died in the next 2 years, would I be comfortable with how this would play out? And you have to think that far because you're not necessarily guaranteed to live that long. So you have to go with the information that you know and try not to plan for every contingency. And then for my parents, even with my parents, for me and my siblings, we get interest only for the first 5 years. And we're doing actually pretty well. Although my half brother, he's kind of wayward. He's getting it together. But what they did is they said, we get interest only for the first 5 years. And then in the 6th year, we get a raise in the principal of 10%. And every 5 years, we get a raise of 10%. They capped our raise, though, at 70%. They want to ensure that 30% makes it to that next generation. So people always talk about, I don't want to control from the grave. You know, that's just too much. Well, if you don't control it, they're just going to spend it. And so if they're going to spend it, it's your money. Why don't you spend it? So why are you concerned about, saving this money, which we all know they're going to blow? Because what they tend to do is say, I'm going to spend that money and I'm going to keep my money, which then once they run out of your money, they spend their money and we're back to square zero and so then square one. And so because of that, controlling from the grave is not a bad thing. And we need to get that out of our mindset that it is. because this is the only way we're going to create generational wealth. And the only way to do it, if you decide that this is something that you're interested in, is trust-based planning. If you decide to do a will-based plan, that's all about getting things to your beneficiaries quickly and efficiently, without court, without probate. If you decide to do a trust, like I said, if you leave things in trust, this is how you create that generational wealth, because you're putting the reins a little bit on your children and your beneficiaries with some terms and instructions, because we can put any instruction in the will. In the trust. I've had clients say, you got to get an estate plan. I've had clients say, you got to get a trust. Screw the will. It's not working. You need to get a trust if you ever want to run this money. Matter of fact, before my son can even run his own money, and a lot of my clients say the same thing, you have to get a financial plan before you can run the money. Now, some of the clients may say you can have 100% access to all the interest and all the principal, but they will say you need to at least get a financial plan. We believe that you'll do well, but make sure you're a good steward with our money. And so one of the things that I think is really important that I've learned is that estate planning is a family affair. You've got to engage people. A lot of people die not knowing that people have estate plans, let alone that they've updated one. So sometimes people are relying on old information, and they assume that, daddy appointed me. No, dad actually updated. Remember when you filed for bankruptcy and he had you in the position of running his money? He made a switch, right? And so people don't recognize that these things are living, breathing documents that can be changed. And it's very important that we have these tough conversations ahead of time, because what ends up happening is people have expectations when a death occurs. They believe they knew you best, or that they should run it because they're the oldest. Well, it's better to flesh all that out now and have those family meetings like we do in our practice, so that we can avoid that drama. Now, the other documents that you have that go along with an estate plan are your financial powers of attorney. Now, no one ever thinks they're going to name someone that's going to run away with the money, but it does happen. And so a financial power of attorney says you can basically, there are no reporting requirements, no instructions. It's usually immediately effective. But what it does is it allows someone to manage your finances. Typically, the power of attorney says only in the event that I can't do so myself. But most of you know that bankers do not sit around and ask to have that loved one come in so that they can evaluate whether or not they have all their faculties. Usually they send it straight to the legal department. Legal department says, looks like good power of attorney. And next thing you know, people are off to the races. What happens is a lot of people are so scared because they are immediately effective. They never tell people they have them. And what ends up happening is a guardianship, where we have to go to court and ask for permission to run your finances. That's called guardianship of the estate. My recommendation, however, is that when you do a power of attorney, you always name two people. It's very, very important that it's an internal checks and balances for yourself. Because even though one person may be doing all the legwork, the fact that the other person could look over their shoulder and check the records, it will give you peace of mind, and all the people that aren't assigned to do the work, it gives them peace of mind that one person's not running the show. And so again, unfortunately, most people don't know the rules of financial powers of attorney, and that they cannot pay themselves. They can only be reimbursed. So just because you're driving mom, dad, grandma all across the city, that's too bad. This is a position of love. You will not be compensated, only in heaven. The next is your healthcare documents, okay? So when we talk about healthcare, that's your other set. So you got your financials and your healthcare. Now, some attorneys will combine them in the same document. I do not like to. I like to separate them. Sometimes your financial person doesn't have a lot of compassion. They're very objective and straightforward, and you need that compassion on the healthcare side, right? And so the first document that you're going to get is your healthcare power of attorney. A healthcare power of attorney says you can sign me into a nursing home, you can sign me into a hospital, or you can sign a contract to have someone come out to my house. It does not, however, say which one you prefer. Again, this is why you want to have family conversations, because doctors don't want to come out to this committee decision and people can't agree. And so in that situation, when it comes to a healthcare power of attorney, you're only going to name one person. You don't name two. And when you have your family meeting, what you're going to explain to this person is, hey, you're the messenger. You're not the boss, unless they really are the boss. But that's the point of the conversation, is to get everything clear. In our practice, we like to have some instructions to help, but there are a bunch of, I guess you call them like checklists or things that help question, the questionnaires. that you can get off the website, off the internet to say, hey, how do you feel about choice of physicians, medications, institutionalized care? I had a lot of clients say they didn't want unconventional courses of treatment if they ever became disabled or had some type of illness. But now with COVID-19, guess what? I got a bunch of calls say, hey, Jennifer, about that unconventional courses of treatment. Hey, if it ain't been tested, I may want to still sign myself up for it. And so your thoughts and your wishes may evolve. And so this is not a one-time conversation. Again, your children, your loved ones don't want to have it, but it's oh so necessary. When you get a power of attorney, or when it comes to your healthcare documents, I like to also have a HIPAA. Sometimes attorneys will embed them in your existing healthcare power of attorney. I like to separate it out. But basically, a HIPAA is the authorization to disclose. This allows the hospital to speak to your named agent. And of course, that living will, which I kind of laid out the distinction before, which is a pull the plug, not on you. You see, there's a wall there. It's the machine. If you don't want to be prolonged with artificial nutrition and hydration, a living will is where you make that designation. Now, please make no mistake. I'd rather you have a healthcare power of attorney than a living will. A living will is just an indication of your wishes. Your agent under the healthcare power of attorney still determines the timing and when we're going to do it, if we're going to do it at all. So the person under the power of attorney is key, because the doctor could come out and say, you only have 2 weeks to live. Let's just go on and, make them comfortable, save you some money. But if you have only one child, that one child might say, do everything you can. Dialysis, chemotherapies, major surgeries, try and save her, even though it's not going to change the outcome. And so essentially that living will, again, it's just an indication of your intent. I also want to caution you on, if you get healthcare powers of attorney from a specific institution, say like IU Health. I have a lot of clients say, well, I got my healthcare power of attorney. IU Health gave me one. Yeah, they gave it to you for their institution alone. If you have to go to rehab, go to Eskenazi, go to St. Francis, they're not going to honor IU's healthcare power of attorney. So it's very important that you get your own separate healthcare power of attorney that's more universal. So I guess the question comes down to, well, what is your journey, right? Sometimes when people sit in my conferences, my mind is blown. I don't know which way to go. Now, my goal is you always think with the end in mind, okay? So when it's all said and done, if you're trying to decide between a will or a trust, what you're trying to figure out is, what do I envision my beneficiaries doing with the inheritance? What do I want them to do? What do I not want them to do? And it will inevitably lead you to the right one, because a will, again, they can do what they want. It's theirs. And typically when people receive inheritances, they buy cars within the first 19 days. So just keep that in mind. When you do leave an inheritance, a car will be purchased. If you do a trust, again, a trust, you're thinking, am I trying to lead to great grands? Am I trying to create foundations or these philanthropic goals that I want my family to always participate in, but I know they won't do it unless I leave them the money and some instructions. If I want to protect people from creditors, lawsuits, they're not good with money, managing their own money, then you might be thinking a trust. So think with the end in mind. It will typically get you there, and then an attorney will help you flesh out the ones that you have questions about. Because what you want to do is get with someone that's going to counsel you, right? You don't want to work with an attorney that's just going to sell you a form, because that form is, as you all now know, is very useless. If we don't know where the assets are, if we don't know what your real wishes are, if you put in the document something we can't even do, right? So I've had a couple of situations where people tried to give away houses they didn't even own. And because the attorney never asked them, does the deed have your name on it? And it didn't. And so then we have these arguments and this bickering when a death occurs about things that should have never been in the will in the first place. So just make sure that when you're dealing and working with your estate plan, that you're working with someone who's counseling oriented. And then of course, get a checkup, okay? So normally when you get your estate plan, we want to put it on our shelves. We feel like great human beings, but you need to revisit it. It's worth the investment to go back over, make sure the goals have changed. The laws are always changing, especially if you do trust-based planning. We had some new laws come out December 20th on retirement called the Secure Act. We've had some new taxation, some new RMD rules. There's a lot of things that happens in a trust-based plan that will require a checkup. The wills are more statutory driven. And so with wills, it's more of family dynamics. If those change, then that's usually when you need to update your will, okay? or if you get new assets too. So the one thing that I always caution people is making sure you understand who's in charge. The goal is you're in charge. This is not a trick question, okay? You want to be in charge of your own estate plan, but oftentimes it's the attorneys because of the fees, right? Because we sit down, we're trying to rush them, we want to get done because their billable hour and all that sounds like is more and more money. And so what you do is you need to ask the questions ahead of time. You know, am I going to be able to update? How much would you charge? Are you billable hour? A lot of attorneys are moving to a flat fee structure like myself. I've been flat fee since I've been practicing. But what you want to do is find the good fit. It's very important. Fit is important. Because, you know, you just don't want to be nickel and dimed, right? People feel like attorneys are always nickel and dime. Everything, where you call, your fax, your email. I sent you a piece of postage. And so these are the type of attorneys that you dread. Hell, I dread them too. So what you want to do is just ask the right questions. And I do, matter of fact, I have a sheet that teaches people how to hire an estate planning attorney, like what questions to ask. I'll send that to Pastor Brian as well. Because there are 3 fees that's associated with an estate plan that people miss. There's the beginning. How much will you charge me for the plan itself? What if I become disabled? If you have no plan, you know you're paying for a guardianship, right? Guardianship of the person is to run the health. Guardianship of the estate is to run the money. If you have your financial powers of attorney, then you just don't want them to get too stale, even though stale is not a legal word. The law says as long as you get a durable financial or durable healthcare power of attorney, it will last the duration of your life. But institutions on their own internal paperwork will say, well, if it wasn't signed in the last 5 years, we're not going to honor it. And so then your loved one has to go hire an attorney to fight a battle that was already done and you already won. And so you want to make sure that you inquire with the attorney about, if I ever become disabled, what would the fees be? In a trust, there is a disability panel usually. It's a combination of doctors and family members that you put in place to make the decision that you can't run your money. And then people can step up and run your money. So it's a little, interim obstacle or test that people have to meet in a trust before you can run be a trustee and run the affairs. And so you want to know from an attorney, if I become disabled, and I need to institute and call to order this panel, how much are you going to charge me to do that paperwork? Because attorneys do the paperwork. And then, of course, there's the fees at the end. When we administer your estate. No one ever asks attorneys, how much are you going to charge my family after I die? And this is where attorneys make all the money, because this is where the family's going on that morbid scavenger hunt while they're grieving. And so you want to know that fee. Now, the personal information form that I'm going to give you, attorneys will always, we're very cautious in our answers. So you always get the it depends. And so I'm going to empower you to say you can figure out the answer. And how you have to challenge the attorney is you have to list out and know all your assets today. And you say, listen, this is everything I own today. If I told you I was terminal and I know the Lord's going to call me home tomorrow, how many hours, because I know your billable hour rate, how many hours would it take to settle up all this stuff? And they should be able to give you an answer if they're an experienced attorney. If they're not, or if they waffle, then you should run. No, just kidding. No, really, you should run. Because the fees are going to be exorbitant. Most attorneys want you to focus on the front end fee. You know, a will, somewhere between $500 and $1,500. A trust. Usually most attorneys are charging 0.5% to 1.5% of your estate size. So the numbers, the assets, people, is where it is. Even though attorneys are billable hour, they're billing towards percentages that if you took them to court, the judge would say, given the size of your estate, that percentage seems reasonable. And so getting a thorough understanding of where you stand financially is the key to understanding the true cost of an estate plan. So you'll want to know the front, right? The middle and the end. Those 3 fees, again, will embody your entire estate plan. Again, I know I can't reiterate it enough. It is a family affair. When a death occurs, your family is not prepared unless they know how to do it, how to pay for it. It's not acceptable to say, this is the attorney's phone number, right? You want them to know what to do, how to do it, and how to pay for it. There it is. I couldn't remember it. What to do, how to do it, and how to pay for it. And if your families don't know that, they're not ready. because then the attorney is running the roost, right? They're in control of that whole entire process. And this is something we can't educate ourselves to know ahead of time. You just have to be committed. And so in conclusion, so here, this slide just kind of wraps up, the types of planning profiles. You're trying to figure out if you need a will or trust. And of course, you'll have your proper powers of attorney, because we want to avoid probate, that morbid scavenger hunt that typically occurs when a death occurs. Thank you for coming. I'm about to answer your questions. And I know some of you may have some, but I'll kick it off by just answering the ones that Pastor Bryant has sent to me in cold. So the first question is, how do I go about removing my name from a deed that's shared with my siblings? So with that, you can there's two ways you can do it. If it's currently in your sibling's name, you just go to the city county building and you quit claim your half to whoever you want to give it to, all of them equally, one sibling or whatnot. You can give away your share. And in Indiana, they allow you to do certain types of deeds as citizens. And one of them is a quit claim deed. So again, there's forms online, I think, for the quit claim deed. I believe the Meridian County assessor even has them in their office where you fill them out and you have to get it. Your signature has to be signed before a notary. There are a number of notaries actually in the recorder's office downtown. It's typically, I think it's $45 now. It's $5 you pay to the assessor for the property tax and assuring that the land is all, it's rightly being distributed and passed. And then you walk down, or you take the elevator down a couple flights, and then you go to the recorder's office to record the deed. And I think they're up to $35 now. So it might be $40. I pay online. They can e-file now, so I pay a little bit more for the convenience of e-filing and getting done quicker. The next question is, I think I already answered this. The 5 most important documents to complete. So again, you're doing will or trust, your financial power of attorney, healthcare power of attorney, a HIPAA if it's not embedded, and your living will, of course. But even more important is the assets. So I'll add that. What organizations specialize in assisting family members who are managing the care and needs of aging parents? You got SECOA. SECOA is the Central Indiana Center on Aging. There you go. CICOA is the initial. CICOA. Or is it OA? Yeah. SECOA. If you just search Central Indiana Office for Center on Aging, you'll find it. But they typically will refer, they have a big plethora of providers that they've kind of, in quotes, vetted that they like to use. But there are a number of institutions and companies out there. Be careful, because everybody that's assisted a loved one thinks that they can start their own business and run it. But it's very hard. Some of the things that you want to watch out for is when you're hiring these people, are they W-2'd or are they 1099? You want to know, are they employees of this healthcare facility? If they're employees, then that means you have a form of recourse if they wrong you. If they're 1099, you have to go after the individual who typically doesn't have the money to reimburse you. So you want to make sure that they have the right coverage if they're 1099. You want to make sure that they're doing drug screenings, that they're constantly training their team that's coming in and assisting. And so there are a number of things that you can watch out for. If you want to email me specifically, I can give you some depending on what the specific need is. There are companies out there called patient advocates. We love to use Clarity Care Advocates. My friend Jane Malkoff. So she's like if you need help with any in-home care, there's a number of companies that I like. But again, there's a bunch of resources. You just need to watch. And I think you can Google there's some good lists. There's been a lot of good articles on what to watch out for when hiring independent agencies. Is there a fee for this service? Some are and some aren't. So with SECOA, they have some that are volunteer and some that, like this week, they have like meals. I donated $100. It's supposed to feed a family for 2 weeks or something. I don't know. But basically, they have some services are free and some are at a reduced rate. So like if you need like grab bars and stuff like that, they have retired, what are they called? Electricians and architects and woodworkers that can come in and do that stuff at really low to no cost. So SEQOA is a great place to start. Then someone asked, mother signed a life estate, quitclaim deed, and an affidavit of heirship. I want to assure my brother. Okay. I want to assure my brother that the house will be decided between us. Oh, okay. He lives in a different state. Okay. So great question. So there are deeds. There's multiple types of deeds. There's a quitclaim, which says, I'm going to pass whatever I own in this property to this person, which if you incorrectly believe you own something and you don't, then that means you pass nothing. Okay. You quitclaim whatever you own. A warranty deed is a type of deed that you sign when you get a house. I mean, this company is warranting that you own this property. And if you are the recipient, you are receiving good title. Then there is a transfer on death deed, which we talked about, which is a deed that passes to a beneficiary upon a death. And then what she's talking about is a life estate deed. Okay, there are great things about a life estate. A life estate deed means while I'm alive, I'm going to give my interest to this beneficiary for their life. But at their death, it goes to this remainder beneficiary, which she's saying is herself. And so what that means is right now, your mother owns this property for her life. If she tries to sell it, nobody wants to buy it because she said in here she's 102. 101 or 102. So no one wants to buy a life estate deed because the only thing that is marketable is your life. The amount of time that you're going to live on this earth is the only thing that they're buying. The minute you die, it passes to whoever that remainder beneficiary is, which is herself. Now that is awesome Medicaid protection because Medicaid can't rob people of their interest in property. So with mom being 101 or 102, if she did need to qualify for Medicaid, the house will be protected. But at mom's death, you can't assure your brother that he's going to get the property because it's going to be yours. The only thing you can assure him of is that when her death occurs, I will give you half, or I will take into consideration what you want. But legally, he is correct. You own that property at her death, and you can do whatever you want with it. He has no say. And so that doesn't give you comfort in going back to tell him unless he gets a thrill out of you telling him he's correct. But what you'll have to do is figure out a way to put his mind at ease that we will do this together. But the other thing you could do is you could do a new deed and have mom, which I would not recommend, but you could have mom re-execute a deed and for her life to herself, and then have you and him the remainder. But you don't want to do that because if mom did need to qualify for Medicaid wants to look to see, have you made any transfers within the last 5 years? And this would be a transfer. So I wouldn't touch the deed. I would just wait. Okay. And just tell them you're going to be a good person. If he needs you to write a contract. I don't know. Then I have another question. It says, how much life insurance does one need if they have elected to pay for final expenses in advance? Okay. You actually have to go directly to the funeral home. So what you do is when you're prepaying for your funeral expenses, you plan it all out. And so it's going to be whatever the budget is that you set up for yourself. And then you can, there are people that sell funeral policies. And so you can purchase one of those for the amount that it's going to cost, or you can make payments to the funeral home. And after a death, if you already have life insurance, your beneficiaries can assign some of those proceeds to that life insurance. But all the beneficiaries would have to agree to sign off on that transfer. When it comes to life insurance, when you prepay, that's a contract. So if you prepay, say Stewart Mortuary goes under, in Indiana, they have funeral trusts. You can take that same contract to Lavinia's, and you would still be able to get the same services that are already prepaid for under that contract. There will be no additional cost that your beneficiary would have to shell out unless they wanted to go over and beyond what you have already set up. This one said, can you please discuss the benefits of a living will versus a trust? I think I covered that and how they're different. Please educate us about the topics listed above. Okay, I did that. I did it all. I think. No. Are there any other questions that anyone has on the call? I think I've answered everybody's that were sent ahead of time. But sometimes these conversations spark more things. Does anybody have anything else?
Well, let me chime in here before we open that up, Jennifer. Let me have a screen if you could, please.
Yeah, go. Oh, okay, let me see. Yeah. This is my favorite screen. You know, I can lead a horse to water.
Yeah, can't make them drink. Well, you led us to the water. You've led us directly to the water. Amen. Wow. Yeah, this was comprehensive. I mean, this was valuable information, Ms. Norton. Thank you so much. I know you've donated this to us, and we appreciate this. And you'll be hearing from us, from certain ones of us. Okay. If you have a question, you can use the raise your hand button there at the bottom on the left. There's a raise your hand thing there. I don't see it now, but somewhere down there.
I do see one question about adding wife to the mortgage. Okay, so there's a difference between the mortgage and the deed. Okay, so we can easily add wife to the deed. So you can hire an attorney to do it, or two, like I said, I'm all about saving money and saving people finances. You can easily go down to the recorder's office and pick up their templated quitclaim deed. I think they even have one online. And all you have to do is exactly how you sign, how your name appears on your deed. You put your name there, and you're going to give the deed to you and her. And then you sign it before a notary, and you can put her name on the deed. With the mortgage, that's a financial contract. So you have to go back to the financial institution and request that it be named to the mortgage, though I bet she don't want that. No, she rather want her name on the deed, not necessarily the mortgage. But yes, that's how you do both of those.
Okay.
And I do offer consultations at no charge. So you're welcome to give our office a call or shoot us an email for an hour consultation, and we'll talk about like your specific situation and see if there's anything I can help you do yourself to empower you, or if there's anything that you need my help with, we're happy to assist.
Yeah, that's the thing. I mean, thank you so much. Certainly, that consultation is valuable. Yes. And I tell people all the time that cheap advice is very expensive, okay? So don't talk to your friends, don't Google stuff.
Yes.
Go talk to an expert. And my wife and I mentioned we have a revocable living trust, got a big binder, looks like this, and everything's in there. It costs a bunch of money, but it brought a lot of peace of mind. We had a conference call with all of our kids, and we explained everything, where the binder is, and the lock box, the fireproof box.
Good.
Yeah. So yeah, let's get into this, people of God. Let's get into this. Let's plan, not just for our death, but plan for our lives.
That's right.
And plan our children's inheritances and grandchildren. Let's get into this. Amen. It's the will of God.
I'm happy to come back anytime you want to go over any topic. If you need to slow down on one topic or another, we can do that. I think for Pastor at Emmanuel, Pastor Webster had me coming in like quarterly for a minute there just to answer. Good. And it was just maybe after Sunday school or something where we come just regularly answer questions and kind of point people in the right direction. So happy to just be a resource. You just let me know.
We would do that, Ms. Norton. We are very interested in this topic. A lot of our members couldn't be on this. Now, I did record this session.
Oh, that's fine.
I'll make it available to the members as well. Yeah. So yeah, we actually stream live to YouTube, and I'm gonna make that private here after we finish here, but make the recording available to all of our members.
Oh, perfect.
So yeah, this is valuable information. I want to unmute everybody so y'all can just say thank you.
Thank you.
Everybody say thank you if you could. Unmute all. There we go. Everybody jump in and say something nice to Jennifer, amen.
Thank you.
Thank you.
Thank you so much.
Thank you.
Thank you. Thank you. Thank you.
Thank you.
Thank you.
Yeah.
All right. Well, you guys stay safe and healthy. And like I said, feel free to call us. We're happy to be a resource.
That concludes our session here. Again, this has been amazing information. Advised us to go, study it. I sent my kids a text a little while ago, said, y'all listen to this. They know some things, but I'm gonna say, y'all listen to this and take the information in, because we want to be faithful, not just to our own generation, but to future generations.
That's right.
Amen. So, okay. Thank you so much, Jennifer.
You have
a great week. Amen.
All right, you too. See you.
Thank you, members, for coming in. Everybody, thank you so much. God bless.
Bye.
All right.